Good afternoon, ladies and gentlemen. Welcome to the SIAC-KCAB International Seoul webinar on perspectives, insights, and trends in Northeast Asia. We are delighted to be participating in the Seoul ADR Festival 2020. My name is Perry, and I am pleased to be your MC this afternoon. Thank you all for taking the time to join us to discuss key developments in Northeast Asia, from trends in overseas trade and investments to the impact of COVID-19 and the implications for cross-border dispute resolution. We will begin with a welcome address of Professor Hee-Taek Shin, the chairman of KCAB International. Professor Shin, please.
Good morning, good afternoon, and good evening, ladies and gentlemen around the world. It is a great privilege and honor for me to welcome you to the SIAC-KCAB International Seoul webinar today. It is one of the opening events of Seoul ADR Festival 2020. Due to the lingering concerns over COVID-19, we have organized all the events in this year's Seoul ADR Festival virtually. While we are unable to meet face-to-face, I am very pleased to welcome the speakers and attendees from across the globe. Today's webinar is jointly organized by Singapore International Arbitration Center and KCAB International. I would like to extend my deepest appreciation to our dear friend Seok-Hee Lim and her staff at SIAC for joining us once again this year at Seoul ADR Festival with this very timely and meaningful webinar. I would also like to express my sincere gratitude to our moderators and panelists for taking time out of their busy schedule to share their insights on the theme of today's webinar, perspectives, insights, and trend in Northeast Asia. Northeast Asia has been one of the most economically dynamic regions in the world economy. They contributed more than 25% of world nominal GDP in 2019. The companies from Northeast Asian economies are most active players in the cross-border commercial transactions. It is very natural that quite a number of them from time to time get involved in disputes arising from their carrying out of international commercial activities. They need efficient, cost-effective, and affordable means of resolution of international disputes. In response, international and regional arbitration institutions have been keen on providing dispute resolution services to the users in Northeast Asia. The arbitral institutions in Asia have begun taking active roles in addressing and meeting specific needs of the users in this region. Since early this year, COVID-19 has been impacting gravely on every aspect of human life, in particular on the way human beings interact with each other. COVID-19 has imposed significant changes as to how international business is being conducted and how international arbitration is being managed. Today, our expert panelists will share their insight and experience on the economic and dispute resolution landscape in Northeast Asia, including the impact of COVID-19 thereon. While we may remain very cautious, so far, Korea has been quite successful in containing the impact of COVID-19. On its part, KCAB International has quickly responded to challenges caused by the pandemic by transforming in-person services in case management, arbitration procedures, and hearings into either hybrid or fully virtual mode. While those changes were imposed on us by necessity, we at KCAB International finds that virtual meetings and hearings have significantly enhanced the efficiency of international arbitration procedure and reduced cost of international arbitration, for instance, by eliminating time and expenses to be incurred by the in-person hearings. Based upon this experience and wisdom acquired during the pandemic era, we are exploring with fresh minds what the most optimal dispute resolution procedure or frame could be when we go back to our normal operation mode. I'm sure you will agree with me that we can take the challenges brought by the pandemic as an opportunity to further improve the dispute resolution system. I hope you will find today's webinar informative and useful. Finally, please join us in the various events of Seoul ADR Festival 2020 to be held from today until November 7th, Saturday, including the 9th Asia Pacific ADR Conference on November 5 and 6, Thursday and Friday afternoons. I wish all the speakers and the participants good health and safety. Thank you very much.
Thank you, Professor Shin, for the very warm welcome. We will next have an opening address by Ms. Lim Seok-Hui, CEO of SIAC. Ms. Lim, please.
Thank you. Good afternoon and hello, everyone. Thank you, Professor Shin, for your kind words. SIAC is delighted to be co-hosting this webinar with our friends at KCAB International. We have a long and happy history of partnering with KCAB on many things. Today marks a new milestone. It's the first time we are co-hosting a virtual event. Although I have to say, I really miss being in beautiful and vibrant Seoul at this time of year for this annual event. I'm glad that we are able to connect virtually thanks to technology. I also would like to thank our speakers, supporting organizations, and all of you for taking the time to join us today. Special thanks to SIAC's Deputy Chairman, Chan-Ling San, and SIAC court member, EY Park, for again giving so generously of your time. It is an exciting week, as Professor Shin had mentioned, with the Seoul ADR Festival kicking off today. Each year has been really engaging, and kudos to KCAB for doing everything virtually this year. SIAC is honored to be a participating organization, and we thank KCAB, in particular, Professor Shin, Sue, and your outstanding team for all the hard work that you've done, and of course, for inviting us again. As Professor Shin said, this has been a challenging year for individuals and businesses around the world. On the bright side, one good thing is that challenges bring opportunities. The pandemic has had a leveling effect. Singapore and SIAC are no longer beholden to the tyranny of geography. What the pandemic has done is to put us on a level playing field with other institutions. And this presents an enormous opportunity for SIAC through our continuous striving to be excellent as an institution, and through Singapore as a trusted hub and legal regime for international arbitration. The COVID-19 situation has sharpened the focus on the factors that make Singapore an attractive dispute resolution hub, an ecosystem which guarantees neutrality, independence, integrity, stability, predictability, and the rule of law. We have constant legal reforms to support this ecosystem, to make it user-friendly, but also to safeguard the rule of law. Singapore has a world-class judiciary, which includes renowned international jurists on the Singapore International Commercial Court that continues to be very supportive of international arbitration. A recent example of Singapore's leadership in dispute resolution is the UN Mediation Treaty, the Singapore Mediation Convention, which is named after Singapore. Arbitration is the international business community's response to litigation. Because of that, international arbitration must be responsive to commercial needs. In these times, more than ever, international arbitration has proven itself to be best suited for cross-border disputes. Hearings quickly moved online as cases continue to be resolved expeditiously. This has been SIAC's busiest year, and we have seen strong growth in our caseload, notwithstanding the pandemic. SIAC has continued to reinvent itself and to adapt to the new normal. We have stayed fully operational through the pandemic. Many hearings have gone virtual, including emergency arbitration hearings, and we recently released a SIAC guide to assist parties with remote hearings. Through webinars like this one, we have stayed open and connected with our users. We held the SIAC Congress, our flagship event, virtually for the first time. We have held online training programs, including the SIAC Academy and the SIAC module at universities, both in Singapore and overseas. We also introduced a live help desk feature on the SIAC website, which allows us to connect with each one of you and to answer user queries in real time during business hours. Currently, our big project is our rules revision. As with our previous rules revision some years ago, where we received over 1,000 comments, we will again be consulting widely with our users and key stakeholders around the world. Korean parties are valued top foreign users of SIAC. Let us know your feedback and any suggestions on how we can further improve our services and our rules to enhance your user experience. I wish everyone an enjoyable and productive afternoon. Thank you.
Thank you, Ms. Lim, for that wonderful opening address. Let me now introduce the panel for the discussion on perspectives, insights, and trends in Northeast Asia. The panelists are Mr. Chan Ling San, SC, Deputy Chairman of the SIAC Board of Directors and Senior Counsel and Arbitrator at Essex Court Chambers, Duxton. Dr. Eun Young Park, Member of the SIAC Court of Arbitration and Co-Chair of the International Arbitration and Cross-Border Litigation Group at Kim & Tang. Ms. Eung Suk Jen, Partner and Head of the Japan Desk at Dentons, Rodike and Davidson LLP. Mr. Joaquin Peterseno, Counsel at Freshfields, Brockhaus, Deringer, Tokyo. Ms. Julia Ji-yeon Yu, Partner at Unim Bazul. Co-moderating the session are Ms. Soo-Hoon Lim, Secretary General at KCAB International, and Ms. Michelle Park Sonnen, Head Northeast Asia at SIAC. A warm welcome for our moderators and panelists, please.
Thanks, Perry. And thank you everyone for tuning in this afternoon. Thank you, Professor Shin, and thank you to Seok-Hui for your welcome and opening remarks. With all the challenges and opportunities arising in Northeast Asia, particularly in light of COVID-19, it is an opportune time for us to take stock of the economic landscape and the trends that we're seeing in international dispute resolution. As Perry mentioned, my name is Michelle Sonnen, and I am the head of Northeast Asia at SIAC. I am delighted to be co-moderating this panel full of their immense collective experience of business and dispute resolution in the region. I'll hand things over to Sue to get us started. Oh, Sue, you're muted.
Right, thank you. Sorry about that. Well, thanks for the introduction, Michelle. And I have to say, it's a real delight to be co-moderating this webinar. I echo what Professor Shin and Seok-Hui said about how wonderful it is that our two institutions are able to collaborate, and that I'm very happy that this webinar was able to go ahead. For those who have seen the program for this webinar, you might have noticed that our webinar consists of a single session and that we will deal broadly with 4 topics. As for the first topic, we'll deal with the micro-level impact of COVID-19 on the international economy in this region, together with the various policies and legislative impact that the speakers have perceived while they advise clients and represented clients in arbitration, especially those clients who are based in or investing in Korea, Japan, and China. So first, let me invite the Dr. E.Y. Park to share some of his perspectives as seen by the legal community in Korea. So E.Y., how would you summarize what has been the impact of COVID-19 on trade and cross-border transactions in Northeast Asia, particularly Korea?
Thank you, Sue. Good morning and good afternoon, everyone. The impact of COVID-19 on the trade and cross-border transaction occurred globally as well as in Northeast Asia. Challenges by the pandemic in an exporting country decreases the scale of production, which leads to a decrease in export supply. Especially exports will decrease in industries and countries where remote work operation is less feasible. In an importing country, it is mainly due to the decreased aggregate demand in that country. It also had an impact on supply chains. Restrictive pandemic measures caused significant disruption in global supply chains. Such measures including closed borders, curtailed travel, and other restrictions. Likewise, trade, cross-border transactions, including foreign direct investment, M&As are expected to decline sharply due to the operational challenges faced by private sector companies. I will briefly talk about the South Korea economy. In the beginning, because South Korea is an export-oriented economy, it has been impacted heavily by the disruption in global demand and supply chains. South Korean exports were down 24.3% in April and 10.9% in June. However, South Korea's flexible approach, refusing to close borders and impose a broad lockdown, and the relative strength of key parts of its export economy have helped to offset the decline. While South Korea experienced sharp declines in exports of petroleum products, petrochemicals, and semiconductors, exports of computers have nearly doubled due to the increased work from home practices. Also, biomedical exports have increased due to the strong demand outside. As a result, South Korea is expected to face smaller economic contraction than other OECD countries. Now, facing the impact of the pandemic on the economy, governments have been taking policy measures to cope with the situation. Policy responses to address the impact of the pandemic can include not only administrative policies, providing financial support programs, tax reliefs, and concessions on import and export duties, but also government interventions in judiciary by excusing relieving parties' contractual duties. It is important to note that the government interventions in judicial decision-making process to nullify or suspend contractual obligations between private commercial parties without affording those parties any process would cause disruption in commercial contract disputes. Particularly in China, the China Council for the Promotion of the International Trade has been issuing force majeure certificates to support entities impacted by the pandemic to obtain performance exemption from their contractual counterparties. The Supreme People's Court of China issued guidance opinions on certain issues of the adjudication of civil cases related to the COVID-19 epidemic, confirming that both the COVID-19 and the relevant administrative measures may constitute a force majeure under the PRC law. The certificates therefore would be enforceable in litigation taking place in Chinese courts. However, if it is governed by foreign laws and be determined by foreign court or international arbitral tribunal, these certificates might be treated differently. In Singapore, the government recently enacted the COVID-19 Temporary Measures Act. The act provides temporary relief from inability to perform contractual obligations and relief for certain eligible contracts. Specifically, the act prohibits the commencement of any court, arbitration, or insolvency proceedings and the enforcement of judgments and domestic arbitral awards related to contractual breaches of eligible contracts. Moreover, the act provides reliefs to financially distressed individuals, firms, and other businesses with regard to the insolvency. Now, what did Korea do? The government has yet to take any action to judicial disputes. So as of now, it is left with the Korean courts or arbitral tribunal to review contract disputes under the governing laws to determine whether there is any ground for exemptions. The interpretation of impossibility or change of circumstances under the Korean Civil Code is still relevant and important. Since force majeure refers to a circumstance where a party is not at default for non-performance of an obligation, recognition of force majeure will allow a party to be exempted from performing a contractual obligation altogether or from damages for non-performance. Korean courts, however, have interpreted force majeure under a very strict standard because exempting a party's obligations citing force majeure leads to a shift in damages or loss to the other party. Korean government, nevertheless, has adopted administrative policies in response to the pandemic that are such as amendment to the Korean Development Bank Act to establish key industry stabilization fund. The government also implemented subsidies and tax reliefs to provide financial supports and reliefs to companies impacted by the pandemic. Lastly, I would briefly talk about the prospects on the post-pandemic era. Supply chains will become more flexible because manufacturers suffered from a lack of flexibility in their supplier bases. Global enterprises will diversify their supply chains in the future. Many companies are looking to bring their supply chain back home, leading to a decentralization of manufacturing capacity. A rapid and wholesale digitization of global trade would reinforce the new model for supply chains. With the help of information and communications technologies, supply chains could quickly switch to alternative providers when regular supplies face disruption. So in conclusion, due to the change in supply chains and non-performance of the existing contract, there will be increase in commercial contracts and contractual disputes and arbitration proceedings. That will be a really good development in the coming days. Thank you.
Thank you. Thank you, UI. That was a very succinct description of the current state. So now next, we'll move to Suk Zen. Suk Zen, I know you're based in Singapore and you advise many clients doing business in China, Japan, and Korea. Based on your advice working with clients and based on your work advising clients, what has been your take on the impact of COVID-19 in this region?
Firstly, thank you SIAC and KCAB for giving me the opportunity here to share my thoughts. So I head the Japan desk at Dentons Rodai. So maybe I'll speak a little bit more about this topic from the perspective of Japan and Japanese businesses. The first point is basically that the economy has been badly hit by COVID-19. So Japan's economy saw GDP fall by about 27.8% on an annualized basis from April to June this year. After the record contraction, most analysts actually expect Japanese economy to rebound in the coming months. And this is also helped by the massive stimulus package introduced by the government. The stimulus package would include things like cash handouts to individuals and affected firms, deferment of tax payments and social security contributions, and concessional loans from public and private financial institutions. Now, on this backdrop, some trends have been emerging in the COVID environment in Japan. I think the first big point is that there is a reduction of industrial plants in China and a relocation of businesses back to Japan. Now, China is Japan's largest trading partner. But due to the pandemic and also due to US trade tensions, Japanese businesses are now becoming more aware of the importance of economic security and stable supply chains. So this has led to many policymakers re-examine the advantages and disadvantages of being heavily dependent on China. In March this year, Prime Minister Shinzo Abe, as he then was, said that where a company is producing high value added products and where the company is highly dependent on a single country, he will want to relocate the production bases back to Japan. And there's no doubt in anybody's mind that this country is China. So Prime Minister Shinzo Abe introduced a $2.4 billion stimulus package to assist Japanese manufacturers to shift production out of China back to Japan and back to countries such as ASEAN. So in doing so, he gave grants for companies to diversify their production bases. Large companies would be subsidized up to half the cost, and then small and medium sized companies would be subsidized up to 2/3 of the cost. And the aim is basically to reduce future risk of supply chain disruption in another case of a black swan event like COVID. I think it's also quite telling that the first overseas stop for Prime Minister Suga when he took over is, I think, Indonesia and Vietnam. And it speaks volumes about where his priorities lie when it comes to cross-border trade. There's clearly a move towards further diversification into Southeast Asia with a reduced focus on China. The other thing is with the reduction of industrial plants in China, there's also a reduction of outbound FDI. So we know that Japan is the world's largest investor since 2018. But because of COVID, there has been an overall reduction in the outward FDI by Japanese companies. Many companies are now taking a wait and see approach. In addition, because of the pandemic-induced economic recession, the balance sheets of these companies are weakened, so it also deters them from making further investments. But I would say it's not a broad brush approach, and it's not the case for all sectors and all companies. Companies with strong balance sheets continue to invest, and many Japanese companies have high levels of cash. And holding on to the cash with low interest rates is just not a good idea. So I think that in the midterm, Japanese companies are actually resuming overseas expansion as a growth strategy. Closer to home, I'm seeing M&A activity pick up for my Japanese clients in the recent months. And with COVID, even with COVID, with the Green Lane arrangement between Japan and Singapore, I actually have clients flying in to do management interviews for their due diligence process. I think on the contrary, in terms of inbound foreign direct investment, the Japanese government has tightened controls on inbound FDI, presumably to kind of like prevent predatory and opportunistic acquisitions at a time where companies are weakened due to one-off effects of COVID. So for example, the Foreign Exchange and Foreign Trade Act now requires foreign investors of certain companies to report in advance if they're going to buy more than 1% stake in the company. This is as opposed to in the past where it was 10%. So you can see various like protectionistic steps added in the time of COVID, whether it's because of COVID or whether they're using COVID as an excuse, we don't know. But overall, I think it remains to be seen what further measures the Japanese Prime Minister, the new Japanese Prime Minister, Mr. Suga, would do to steer the economy. And it is especially exciting being based in Singapore, the heart of Southeast Asia, in these times. Yeah, I think that sums it.
Okay, thank you. That was very interesting. And now that you mentioned a jurisdiction of great interest to us, Japan, I think it would be interesting to hear from Jack, who is now based in Tokyo. So Jack, what do you see as the primary impact of COVID-19 from someone who's based in Tokyo and has been advising many Japanese clients doing business overseas?
Sure. So thank you, Sue, and thank you to SIAC and KCAB for inviting me to the panel. I'm going to assume that there's a nice big audience out there because I know that these two organizations always do draw a lot of attention. It does feel a little like speaking into the void, but I know that you people are out there listening. So I'm just going to add a few points on the trade and cross-border transactions in Northeast Asia, particularly in Japan, and the impact of COVID-19. Just picking up on some of the things that Suksen mentioned, we are seeing in Japan an increase in cross-border M&A in the third quarter. It had, of course, been down in the first and second quarters this year, unsurprisingly. But we're not seeing as much of a pickup as a lot of us expected to see. We're seeing what you might think of as a bifurcated market. I think there's some very attractive assets for M&A in technology and in pharmaceutical industries. But then there are some less attractive assets, unsurprisingly, in the more industrial industries, and particularly in the leisure industry. And right now, I think we're not really having a good opportunity to predict whether the pickup we've seen in the third quarter will continue as we go forward. Particularly, of course, we've seen spikes in COVID now in Europe and in the US, and further lockdowns recently. So it remains to be seen how long those increased problems are going to last and the effect that they might have here in Asia, and whether we start returning to something more like we saw at the beginning of the year, where deals are slowing down. And this can be particularly true for the Japanese corporates, what of course we all know as Japan Inc. They are doing fewer deals than we might have expected. As Suksen mentioned, a lot of them do have a lot of cash on hand. And there's the expectation that they're going to want to invest that cash. And so there was a sense, I think, at the beginning of the pandemic, or at least as we got into March and April, and we knew that some assets were going to be coming on the market at some bargain prices, that this might be a great opportunity for the Japanese corporates to take advantage of that and to invest that money and get a lot more for their money than they would have last year. But we really haven't seen a lot of that going on yet. Again, there's been a bit of an uptick recently, but not what we might have expected. And I think in part this is because the Japanese corporates are traditionally more risk adverse compared to their European or their US counterparts. So we're seeing some big deals happening, but the Japanese corporates are doing fewer than we expected, and they're not involved in as many as we expected. That said, you're seeing things from SoftBank doing some M&A. There's, of course, the 7 Holdings did the big USD 22 billion deal recently. So they are out there and getting active, but it's more limited. And when they are getting active, it seems, at least so far, that they're getting active in these big ticket deals. And they're not doing as many of the smaller bargain deals as we might have expected in this environment, and given that they have plenty of cash and they have at least a motivation to be buying foreign assets and to be expanding their business, particularly given the shrinking market and the aging population here in Japan. But again, they're doing this less than we might have thought. What they're doing instead, it seems, is focusing on divesting their non-core assets around the globe. As we're all probably aware, a lot of the Japanese corporates have a huge portfolio of assets in a wide range of industries. I can still remember when I first moved here in 2017, looking at a brief summary of one of the trading houses who I was going to meet with, and seeing that their business interests raised from chocolate and candy making to air conditioning to owning nursing homes in the US and to apparently building warheads for defense contracts. So they really have an amazingly broad range of businesses. And what we're seeing now in the wake of the pandemic is some of them trying to divest of these non-core assets and find a way to more focus their business so that when these kind of events happen, they're a little more agile and a little more able to respond to it. One way that they could be looking to expand the businesses that we expected, but they have not been doing yet, is in the area of distressed M&A. Right now, we think distressed M&A is not as attractive as it may become, and so far the Japanese corporates are staying away from it. They're showing a reluctance to go after distressed assets and adopting, as Suk-sen said, a wait-and-see attitude in this area as well as in others. And what we're seeing from some of them is an apparent preference to sit back and wait for private equity to pick up these distressed assets, to turn them around, and then the Japanese corporate might be interested in buying them from private equity firms. So in doing that, they would miss out on the bargain deals, but they would be taking less risk, and they would be getting an asset that had already been turned around. So we're seeing a little more interest in that than in them actually becoming involved in buying the distressed assets themselves. So again, they're adopting this wait and see approach still. In the current situation, this is even more so. I think we had a sense here in Tokyo, I think in September, that after everybody came back from sort of the summer break and working from home for several months, most of our clients are actually back in the office. They're either doing 50% teams at a time in the office. Some of them are even essentially full-time back in the office. And I think there was this sense in September and October that things were getting better and that it was going to be back to business as usual. But again, the last few weeks have put a bit of a damper on that. And I think it's made many of the Japanese corporates, again, pull back and think about being a little more cautious than companies elsewhere around the globe might be. What we are expecting is a wave of domestic M&A, because they're very comfortable with how things are going in Japan and how the pandemic is handled in Japan. I think they have a greater sense of what assets are worthwhile here in Japan without being too risky by reaching out across the globe for things. But there still seems to be a strong pessimism in Japan generally, despite how the pandemic has effectively been positively handled here. They remain more pessimistic than you might expect. And in the end, I think this is a bit of a shame, because they're missing out on some good deals and some bargain deals that they might otherwise be taking advantage of, again, because many of them do have this cash on hand. But we'll just have to wait and see how things develop over the coming months.
Okay, but thank you, Jack. Thank you. So far we heard from EY, Suk-sen, and Jack on the overall macro level economics. I had hoped to have some time to listen from Julia and Ling-san as well on this topic, but in this interest of time, we'll move on to topic 2, where we'll hear from both speakers as well. So topic 2, I'll ask Michelle to moderate and listen to our speakers. So Michelle, over to you.
Thanks, Sue, and thanks Suksen, and thanks EY and Jack for those insightful comments on, the state of the economy in Korea and Japan. I think with that backdrop, it's a good time to sort of zoom in a little bit and focus on dispute resolution specifically, and what are the kinds of trends that we're seeing, some of which arising out of COVID-19 and some of it, predating COVID-19. So if we could get started with Lung-sun, perhaps you could tell us, in your experience, what is the impact that you're seeing of COVID-19 on disputes, particularly in disputes involving Northeast Asian parties?
Good afternoon. Well, Michelle, I think that the impact on disputes will probably only be felt in full from next year onwards. I think for the first 6 months, companies have been holding out, trying to pedal harder, trying to keep afloat. Some have not managed to, some are still struggling, but I think we have seen, and anecdotally, that by end of this year or early next year, some companies might not be able to hold out much longer, and that's the troubling trend. Disputes have not really broken out in full because of COVID-19. The effects, the economical effects have already been felt, but you do not see many cases coming for arbitration that arise out of COVID-19 for the moment. You do see disputes arising in some cases, especially on trade, due to disruptions to supply chain, due to non-performance of sale and purchase of contracts and so on. But not many actually can be pinned to COVID-19. There could be a few. We have seen some insolvency arising, for example, because companies just couldn't hold on anymore. And those insolvency cases have actually been blown out wide open. In Singapore, we have seen the bunker trade being affected particularly badly by the, by the one of its biggest Singapore trading companies being unable to cover up its past year losses anymore. It had been trying to do that, but with COVID-19 and the downturn, it just wasn't able to cover up the losses anymore, and then everything got exposed. And there have been a lot of knock-on effects on other traders. But we can certainly see that there will be a lot more trade disputes, those, as I mentioned, relating to sale and purchase, relating to supply chain. We have seen as well from SIAC's experience that trade disputes have always been one of its biggest sectors of cases coming before SIAC in the last few years, even before COVID-19. When it comes to a country breakdown for Japan, for example, in 2019, trade disputes that come up for arbitration before SIAC formed 33% of the disputes from Japan. And that's a fairly significant number. Likewise, for Korea, it was 25% of the Korean-related disputes that came up to SIAC for arbitration. For China, it was 27%. So you can see that it's always been a significant number. And we suspect that next year there might be even more of that. But certainly other areas will be affected. I think this pandemic has affected everybody. I don't think anybody has come out unscathed. You see infrastructure, energy, other commercial sectors being affected as well. And one big area that I want to touch on right now would be the impact it has on BRI, right? BRI had been the big topic for a couple of years before pandemic. And in 2019, China's trade with BRI countries totaled $1.34 trillion US. And it has stimulated activities along 6 economic corridors spanning Asia, Europe, and Africa. It's inevitable that given the size and complexity of these projects, you will have some questions over exposure to non-performing loans and also non-performing projects. And even before COVID-19, China's funding of energy sector in BRI countries had fallen from $10.4 billion in 2018 to US $3.2 billion in 2019. And when the pandemic kicks in, you can find that in 2020, certainly the prospects are grimmer. An Untitled report forecasts that foreign direct investment inflows to the Asian region in 2020 are expected to decrease by 30 to 45% as a result of the pandemic. EY has already mentioned China's issue of force majeure certificates. As of March, over 5,600 certificates have been issued. And this covered values up to 72.47 billion US dollars. And as EY had mentioned, the question whether these certificates would be recognized in other countries under other laws is a matter of guesswork. Some will not. And again, you will see a lot of disputes coming out from this sector, Michelle. Certainly, we will see a lot more disputes relating to force majeure, to frustration, and material adverse change that you find these clauses in financing contracts, in mergers and acquisitions. You may find some companies trying to invoke these clauses as well.
Yeah, I think that's all very interesting. And the trade disputes that are likely to arise and the types of defenses that we're going to be seeing, interesting to see that we'll just kind of have to wait and see how these certificates, for example, are interpreted under different laws. Thank you for that insight. Now, maybe you could also talk a little bit briefly about one of the most obvious trends that we've seen, which is virtual hearings. You sit as arbitrator all the time. What are your thoughts on what works and what doesn't? Just a few quick points on what works and what doesn't from the tribunal's perspective.
Sure. Well, just to see things in perspective, video conferencing had always been in play in litigation and in arbitration, but prior to the pandemic, it had been the exception rather than the norm, because witnesses are expected to be at the hearing where the counsel can see them in full flesh and try to rattle them. The tribunal can see the demeanor of the witnesses and so on. But since the pandemic, virtual hearings have become the norm, even in courts in Singapore. We have been carrying out hearings by Zoom. Even after the lockdown, the courts have found that, hey, virtual hearings actually work. We don't need you to come to court physically. Let's carry on. And we are still doing Zoom hearings, even though the lockdown has ended. Now, with regard to arbitration, I think that parties as well as counsel and arbitrators have found that Zoom hearings can work. I don't think they will be a complete substitute eventually, hopefully, when we get back to more freedom of travel. You will find more physical hearings in person. But by and large, I think parties have found out that they can actually do things a little differently without travel. So I think in some cases, you will see that as a norm. And the tribunal needs to organize that very carefully, way in advance, much more so than a physical hearing. So you need to set in advance the protocols and a very detailed hearing schedule. You may need to break up the hearings in tranches due to the time difference. So that's what we are seeing.
That's great. That's very helpful, I think, for parties just to be aware that it's entirely possible. It just takes a little bit of advanced planning, and your counsel will still be able to rattle the witnesses of the other side. So fear not. Thank you very much for that. If I could just move over to Julia to actually give us a few quick comments on the counsel's perspective of what works and what doesn't on virtual hearings. Would you agree with the tribunal's perspective? Oh, I think you're on mute, Julia. There we go.
I think there are some practical tips from the counsel's perspectives to successfully hold the virtual hearing and to avoid pitfalls that may give rise to challenge. So let me introduce some suggestions. First, I think the pre-trial consideration will be very important because engage the other parties to the arbitration in the tribunal as early as possible to work out the hearing logistics, because there are more logistical issues to consider for the virtual hearings than in-person hearing. And the presentation of document with evidence will be also important. parties should prepare an agreed e-hearing bundle that is properly hyperlinked so that the documents can be easily pulled up and presented by a screen share during the hearing. And ensure the witness have a clear video connection to allow counsel and the tribunal to observe their manner during the witness examination. The clarity of audio connections is also vital for the witness testimony to be accurately transcribed and interpreted. And the contingency plans should be made for potential internet downtime, as these can happen notwithstanding rigorous testing.
Julia, sorry, if I could interrupt you for a minute. I think some of us are having a little bit difficulty hearing you. Is it possible to turn your volume up a little bit?
Sorry.
Is there a volume setting for your microphone?
So can you hear me now?
I think it's a little bit better.
Oh, okay.
Great.
Yeah,
But yeah, that's better. Now that's better. Yeah.
Okay.
Sorry about that. Please continue.
So I think the parties and the tribunal should also agree in advance the extent of the recording to be permitted for the virtual hearing. Unless the parties agree otherwise, recordings are typically only made for the benefit of the stenographers and should not be released in any way except by consent of the parties and approval of the tribunal. So these are some like the suggestions to have the virtual hearing successful.
Okay, great. Thank you for that. I wanted to mention for those watching that, if you have questions throughout the webinar, please do feel free to use that Q&A function on the bottom, and we will try to get to your questions at the end of the webinar. Okay, turning back to Julia, thank you for those comments on virtual hearings. I think it is important for parties to be aware of from the get-go of the kinds of issues that they do need to be aware of. And if I could actually go back a little bit to what Lung Sun talked about with respect to force majeure, and also Dr. Park, as a Korean lawyer now working in Singapore, advising Korean clients, Singapore clients, and others, what do you tell your clients with respect to whether they might want to rely on the force majeure defense in their kind of trade disputes that might be arising out of COVID-19? Maybe we're at the stage now where parties are actually considering what are my options and how should I proceed with this case, and how is it going to turn out?
Well, I think I have seen many Korean companies contemplating the option of applying the principle of force majeure to assess the suspension or termination of their organization's the contract. And I suggest to understand what differences exist between the civil law perspective and the common law perspective in terms of force majeure. And Dr. Park actually briefly introduced about the Korean court stance about the force majeure. And I think the most of Korean companies' contracts actually, when you see the governing law, you will see the governing law is not the Korean law and mainly like the English law or the Singapore law. So to understand the common law perspective will be very important for the Korean companies. From the common law perspective, when the contract is governed by a common law system, the court will generally start from the presumption that the parties are free to agree on all matters, which includes the freedom to agree to widen or narrow relief in force majeure situations. Generally, force majeure provisions are interpreted by focusing on the actual language used, with the result that each case rests on its own contractual language and set of facts. Therefore, understanding the contractual wording in common law jurisdiction becomes critical for Korean companies to try to understand their risk exposure, mitigating factors, and potential remedies. Then, what should Korean companies consider, especially where the governing law is not Korean law? First, review your existing contract in order to determine if all your contracts contain a standard force majeure clause. And when force majeure clauses are not mentioned, whether there are other similar hardship clause or wording on non-performance that should be considered. If your company wishes to claim force majeure applies, whether there are any procedural requirements such as notification protocol that must be followed, and identify possibilities to avoid or mitigate non-performance of the contract. For instance, a party seeking to rely on force majeure may be subject to a duty to show that it has used all reasonable endeavors to avoid the effects of the offer. And you need to consider whether you have assessed the actual cost of the alternatives to non-performance. And last, and what are the other parties in your sector or geography doing in relation to non-performance during the current crisis? So these are the factors the Korean companies need to consider when they try to rely on the force majeure.
Sure, sure. Yeah, so just to quickly recap, make sure you check out your contract language, check for the defense or any other types of possible defenses written into the contract language. Make sure you comply with any prerequisites, whether that's giving notice or trying to mitigate. And then, the last point, see what everyone else is doing around you in the industry as well. That's great. Thanks, Julie. I think that's really, really helpful advice. If I could just real quick over a few minutes, turn back to Suk-sen to talk a little bit more about Japan and the dispute resolution sphere. I do understand that Japanese parties have historically been more inclined to avoid disputes if possible. But at SIAC, we have seen the number of Japanese parties increase steadily over several years. As well as the size of disputes. And in your view, does this signal that Japanese parties are becoming more open to pursuing international arbitration?
I think, Michelle, you're absolutely spot on. The Japanese psyche is a conciliatory one. And I still continue to see that Japanese prefer to settle before going on to a full-blown dispute. That said, international arbitration has increased in importance in Japan in recent years, especially for a cross-border transaction where there's a Japanese party entering into a joint venture with a non-Japanese entity, for example, in Vietnam. Parties tend to prefer to resolve any dispute arising from this from a third-party neutral country, and in this case, by SIAC. So we see that a lot for the past 4 to 5 years, I would say. On the ground, I think there have been initiatives to promote cross-border arbitration, and I think that's great, and that has caused the spike in cases or the gradual increase in cases in SIAC for Japanese companies. So the creation of the Japan International Dispute Resolution Center, I think many of you would be familiar with. In 2018, JIDRC was started, and it started the first dedicated facility in Japan for international arbitration and dispute resolution. So while we take things for granted in SIAC, Japan is a bit late to the game. The JDRC Tokyo was just opened in March this year. The first one was in Osaka. But it's also timely because with these facilities, virtual hearings are now made more accessible, and social distancing during the hearing is also much easier. The second point of on the ground change that we've seen is the amendment of the Foreign Lawyers Act to allow non-Japanese lawyers to represent Japanese parties. So in the past, if both parties of a proceeding was Japanese companies, registered foreign lawyers would not have rights of representation, even if one or both of the parties are owned by a parent company incorporated outside of Japan. That non-Japanese law governs the proceedings, or that foreign arbitral rules apply, doesn't change this position. But from 29th of August this year, the registered foreign lawyers would now be able to represent clients in arbitrations with all Japanese parties where there's a sufficient international nexus. There's also an amendment. Yeah, go ahead.
Oh, no, continue. Sorry, I thought you were wrapping up there.
So the last amendment that I'd like to talk about is the amendment of the Foreign Lawyers Act to essentially make it easier for foreign lawyers in Japan to become registered foreign lawyers. So in the past, foreign lawyers would be required to have 3 or more years of experience with a maximum of 1 year of practice in Japan counted towards the total. And now this limit has increased to 2 years of experience in Japan, thus making it easier for junior lawyers practicing in Japan to qualify. So all this helps in creating an environment that is conducive to international arbitration. And I think that's why we have seen a gradual increase in the number of cases for Japanese parties.
Sure. Thank you for those insights. It is interesting to see how the market is developing, particularly in Japan, as international arbitration does become a more commonly used dispute resolution mechanism. We are starting to run short on time, so we're going to move on to the next topic, and I will hand it over to Sue to talk about, enhancing efficiencies in international arbitration and so on.
Thank you, Michelle. So we're now in topic 3, and as in any changes or developments we see around the world, arbitrator practitioners are quick to seize the opportunity and find ways to enhance efficiency, lower costs, and whatnot. So this is the subject that I would like to ask 2 of our speakers to talk about. First, Jack, I know aside from advising clients, you also represent them in arbitrations. What would be your thoughts on what would be the initiatives to enhance efficiency and lower costs in the COVID-19 situation?
Yeah, thank you. I think this is a topic, it's coming to the forefront a bit in the wake of the COVID-19 pandemic, but of course it is not something that is really created by or that related to the COVID-19 pandemic. In fact, I think we all know that there's been a long-running criticism of international arbitration as getting more and more expensive. It was originally seen as a cheaper alternative to litigation, but I know a lot of practitioners and clients feel that is just not the case anymore, that it is now as expensive or even more expensive than litigation in national courts. To be honest, I question this. I've always found that if you have a case of comparable size and complexity, I still believe it's going to be much more expensive to pursue that case in the courts, particularly in a jurisdiction like the US or the UK, than in arbitration, unless the exception being you can knock the case out early with motions to dismiss, for instance, in the US. So I think one thing that we've been seeing from SIAC and from other, and KCAB and from other institutions is changes in the rules to allow for early motions or early efforts to try and get rid of claims that might be frivolous so that you don't have to go through the entire arbitration process. But I think a lot of the reasons that arbitration can become inefficient or more expensive than it needs to be are due to things like unnecessary complications and futile arguments that counsel and clients raise anyway, overblown and extensive document requests. These kind of things are part of what we see increasing the costs of the proceedings. So for an example, you may simply get a party stubbornly refusing to agree with the counterparty on certain points, or not being willing to get together and try to work out issues of procedure or ways that they can make the process more efficient. This is not that surprising, of course, because once they are in a dispute, a lot of times they can't agree on anything. And so even the simplest matters as to how the procedure is going to be run become these, letters after letters to the tribunal and requiring a jurisdictional or a procedural decision from the tribunal. That, of course, just raises the cost of the proceeding overall. And this is often, to be honest, driven by the clients. Often as counsel, we try to get our clients to simply agree to things to keep things being more efficient, but the clients don't want to take that approach and want to take a very firm stand against anything that they perceive the other side wanting or the other side benefiting from. And then, of course, you also have what might be called the kitchen sink approach to pleadings. we've all seen this when you throw in every possible claim or every possible grounds that you might, you know, if you're bringing a treaty case, for instance, you're likely to see claims for indirect expropriation where, you know, we all may know as counsel that there's a very small chance of that claim actually succeeding. And really, maybe you just want to focus on the violation of fair and equitable treaty claim. But we all find ourselves, and again, some of it's counsel driven, some of it's not, you know, feeling like you certainly don't want to get to the end and lose on one claim and think that, well, maybe if I put in this other claim, I might have won. So we do this, and you see these very pleadings that cover a lot. And if that could be limited, if pleadings could be more concise, if you could maybe find ways to focus things better on the claims that are actually more viable, that could also reduce costs. You can also reduce costs through more regular conferences with the tribunal. And I think this is where our experience that we're having now due to the pandemic is really going to be able to make a difference. Everyone is becoming much more comfortable with doing things virtually, like we're doing this seminar. And so I think that is going to help people do more conferences with tribunals. A lot of times I've done cases where we have the beginning conference with the tribunal, you know, before we start putting in any of our written submissions, and then we almost never see or talk to the tribunal again until the hearing. There'll be a lot of letter writing, there'll be emails back and forth, but we won't just get everyone together to have a conversation about some procedural point. Where if you could do that, or if you could get together after the first round of pleadings and maybe have a conversation about exactly how document production should be approached, or what really have we been able to narrow the issues for the next round of pleadings. If you're able to do that, you could save a lot of money, you could make things a lot more efficient. And I think that the fact that we're all becoming much more used to the virtual conversations and virtual meetings will allow us to perhaps do that and to build that into our procedural orders right from the start, so that we start doing more of those kind of hearings and start saving a lot of time and money doing that. This, of course, also could lead to virtual hearings versus in-person hearings. We all know that there's a great deal of talk about that in the last 6 months. I've heard people say that the new norm is going to be virtual hearings because everyone's learning that they can be done. Personally, I disagree with that. I think once we're able to, we will see a return to in-person hearings, at least in the majority of cases. I think there's a great deal of value to in-person hearings that you simply won't get from virtual hearings. But there will, I think, again, be a greater use and a greater comfort with doing some things virtually, including parts of the hearings, or perhaps have some witnesses testifying virtually, where in the past, maybe if they couldn't come to the hearing, they simply wouldn't be cross-examined. So I think those are some of the ways that we're able to see more efficiency and see some time saving for that, some of it coming again out of the experience we're all having now because of the pandemic.
Thank you. Thank you. I agree. I can agree with your point that virtual hearings can always mix some of the in-person elements as well. And I think that was the thinking we had behind when KCAB announced the Seoul protocol on video conferencing and witness testimony, because we noticed that many of the Korean companies had witnesses who found it difficult to participate in hearings because of the physical distance of the hearings. But anyways, that's good to know. And so for this topic, the next speaker I would like to call on is Ling Sun. And I noticed that in the previous topic, you mentioned that doing hearings virtually is different from in-person hearing. I wasn't quite sure if that different was much more efficient and cost-effective, or it was just different in other different ways. So I would be interested in hearing from you on that.
Well, it is different, both in terms of cost and I think in terms of the experience. You do save costs by not traveling. You certainly save some time by not traveling. In that sense, it is efficient, but you lose something. I agree with that I don't think it will completely replace physical hearings when we cannot travel again, because it gets rather tiring staring into the computer screen for a whole day. It takes a lot more out of you, and the level of concentration might not be quite there. As to whether you can conduct cross-examination effectively, I think Michelle alluded to that. I think you can. My own experience is that you can actually do that. Arbitrations are not like American TV shows where the counsel lean into the witness's face and get in the witness face, right? Even in a typical physical hearing, you keep your distance. And you can see the witness demeanor by Zoom. But you do have to arrange things quite differently. You have to allow for the fact that the parties themselves may need to consult, the tribunals will have to consult, so you need to arrange breakout rooms. And for this reason, I always recommend that the tribunal itself does not try to host the hearing. You should just make use of service providers like KCAB, Maxwell Chambers, ICDR in the US, and so on. All private providers like Opus to manage the virtual platform and also to manage documents for parties. So you got to think a lot more about how are you going to manage documents for witnesses to look at and also for the tribunal to look at. But in terms of saving costs, I think you will save some costs, but whether that the savings in cost ought to replace what you might otherwise lose in physical hearing, I think that's a balancing act you need to do. As what Jack says, is I agree with him, there might be some aspects of the hearing that you don't need everyone to travel for. Certainly case management is not something you need to travel for. And perhaps some tranches of the hearing can be done virtually. So we all just have to be much more creative and flexible going forward.
Okay, well, thank you for that. Well, as we were talking about this topic, I was also looking at the Q&A box and I noticed there's a question. I don't know whether Jack or Leng-san, either of you want to answer, but there's a question that goes something like this. Would it be advisable to include that a virtual hearing would be advisable, or at least it ought to be a mandatory type of manner of conducting hearing? Or would you advise or advise against including a clause like that?
Yeah, I mean, I can take that first. I would advise against including a clause like that, making it mandatory right from the start. You never really know what the situation is going to be. You never know who your witnesses are going to be, whether you might realize that you really want to have it in person, or as one party you might want to, but the other party sees an advantage for whatever reasons to keeping it virtual. I think you can, if you feel strongly about it, you can put something in the clause along the lines that, you know, the parties will consider having the hearing virtual or something along those lines, but I certainly wouldn't make anything like that mandatory from the start before you even know what your dispute is.
Okay, all right, thank you so much for that. All right, so I think we are to our very last topic and probably our last quarter of the hour. So I'll hand it over to Michelle to conduct the last part of the webinar.
Thanks a lot, Sue, and thanks, Jack, and thanks, Leng-san, for the interesting comments on efficiency and virtual hearings. You know, one of the topics that comes up a lot when we talk about efficiency and changes to international arbitration is, well, is there another way, and what about mediation? And in this webinar, because we are focused on international arbitration, we want to think about, well, how can arbitration and mediation sort of complement each other? And how does mediation impact international arbitration? And if I could turn first to EY, you know, with the entry into force of the Singapore Convention on Mediation, parties now have even greater access to international dispute resolution. Are you seeing that companies are increasingly considering international mediation to resolve their disputes?
Thank you, Michelle. Yes, certainly the company is always thinking of mediation as a means to resolve the disputes. for many reasons. They would like to avoid any, dragging on procedures or high costs, either in arbitration or litigation. So to that end, I would say that companies will generally prefer mediation. The problem is that the mediation may not have a finality, and there's enforceability issues. Recent, enactment, ratification of SIMC will become a new, really era or a phase in terms of use of the mediation. The Singapore Convention on Mediation came into force on September 12, 2020, so that the enforcement of cross-border mediation agreement became much easier. And because of that, on May 18, 2020, the Singapore International Mediation Center, SIMC, launched the COVID-19 protocol to provide a business with an expedited and economical mediation process. So institution has done a lot of work to lower the bar for the users to use the mediation. And also, I guess that because of the COVID situation, as some companies have made special measures, such as COVID-19 Temporary Measures Act enacted by Singapore. Mediation may be very useful tools because the Temporary Measures Act imposes a moratorium on certain legal actions to give parties breathing room to work out their differences. So the protocols I mentioned from SIMC may give parties to chance to have a mediation at any time to settle their disputes, even if they enjoy relief under the Act. This is important because contractual obligations are not absolved under the temporary relief measures under the Act. At the same time, because of the pandemic, a number of countries are actively promoting the use of mediation and ADR due to the difficulties coming out of pandemic issues. So the enactment of the Singapore Convention, the special laws, the efforts of the institutions all work together to encourage the use of mediation and allow cost-effective measures. So I would say that yes, mediation will be more commonly used than before. Thank you.
Thanks, EY. I think that's very helpful. Julie, if I could get you to just chime in with a few additional comments on mediation. We see sometimes that parties like to use this hybrid approach like arbitration, mediation. Arbitration, in fact, SIAC also has its own ARB-MEDAR protocol that we do encourage parties to use when they're considering mediation as well. Could you talk a little bit about that and how it might benefit parties?
Okay. So as Dr. EY Park mentioned, it would be true that the Singapore Convention could somehow allow the Arbitrations Act. However, arbitration and mediation should not be envisaged as competing tools to solve the disputes. Instead, combining the best of both worlds would optimize the dispute resolution process. Practically, a mediation can be combined with arbitration at three different stages. First, before arbitration, as the first tier of the escalation course, like a med-up course. And second, during the arbitration, when parties reach a settlement, notably with the help of the mediator, and request the tribunal to render consent award, so-called ARB-MEDAR protocol. And even after the arbitration, as a means to reach a settlement regarding the quantum to be paid and avoid, therefore, enforcement issues. So recently, I have one case where the both parties actually reach the settlement agreement after the first stage of the liability stage, and when the result before the result come out, actually both parties successfully reach the settlement agreement about the content. So I see the successful mediation even after the arbitration.
Right. Great, thank you. You know, this is a huge topic and we would love to spend more time on it, but unfortunately we are sort of winding down here, and we want to be able to answer some of the questions posed by the audience. So we're gonna have to wrap up that very brief discussion on mediation, but thank you, Julia, and thank you, EY. You know, we had a question that came in about enforcement, and in particular, enforcement of awards in China with respect to cases that arise out of the BRI. You know, Lung-san, I know you had mentioned BRI earlier in your discussion, so maybe you could tackle that question for us?
Sure. Well, one thing to bear in mind about BRI is that you might not be looking to enforce an award against China. You might actually see China trying to enforce an award because China is a big investor in the big BRI countries. And for that reason, in fact, many Chinese state-owned companies and many big Chinese companies are looking to arbitration and provide for arbitration in their contracts because they want the awards to be enforceable. So you may have a situation where the award is made outside China and is being enforced by a Chinese party. And certainly we have seen cases where Chinese parties are successful in arbitrations and then seek to enforce awards. But if you do have a situation where you are an investor and you have a Chinese contracting party counterparty, then you want to enforce a New York Convention award in China, that's certainly possible. China is a party to the New York Convention. And what you do is you bring the award to China, you go to the intermediate court in the place where the debtor is located or the assets are located, and you start there at the intermediate court. What's interesting to many people is that China takes enforcement of foreign awards quite seriously. And for that reason, if a lower court decides to refuse recognition or enforcement of a foreign award, it is bound internally by internal guidelines to refer its intended decision to a higher court. And then it keeps going up to the Supreme People's Court so that the Supreme People's Court can have a final say on whether to actually refuse enforcement. And that's only if the lower court decides not to enforce it. If the lower court decides to enforce it, it doesn't have to refer it all the way for the Supreme People's Court to the Supreme People's Court for review. Okay, I should be brief because we are short of time.
Thank you. I think it is useful to know that the court structure there. So to recap, you know, they're only going to have a right of appeal if parties are only going to have a right of appeal if the enforcement is refused.
It is not an appeal process. It's more like an internal review before of their intended decision.
Okay, and then, but if it's going to be enforced, then that decision becomes the decision, the court's decision.
That's correct.
Great. That's very interesting, and I hope that answers the question to the person that posed it. You know, we also have another question that's come up about mediation, and someone is asking whether you actually advise parties to have a mediation before the arbitration is initiated. And I think this question goes to the timing of a mediation when you're looking at one of these hybrid approaches. Maybe I could ask EY or Julia if you want to share your thoughts on when is the best time to do a mediation if you're thinking about doing this hybrid approach.
Yes, certainly. There's many cases where the dispute resolution will be based on the multi-step. You do the mediation first, and then in the failure of the mediation settlement, you go to the arbitration. That is a useful tool. Having said that, you should be cautious in implementing it because many circumstances when you are doing arbitration, one party may raise an issue of the unfulfilled requirement of the mediation sessions. So you should be very clear as to the the requirement of the mediation and try to fulfill the requirement, because otherwise your arbitration will be stalled due to the lack of jurisdiction. So that's also a balance issue. Thank you.
Julia, is there anything that you might add there?
Okay, so if you want to consider about the system, and I would like to advise that you need to be very careful about the time frame for the mediation. Otherwise, it will be delayed, and the both parties would not find the efficient dispute resolution just doing the mediation. So I would like to ask the parties to be concerned about the time frame for the mediation.
Yeah, great. Thank you. Okay, let's move on. There are some questions, lots of questions here about virtual hearings. You know, this has been quite a hot topic in the age of COVID-19. One question is, how do we ensure that a witness is not being compromised in cross-examination? And again, this is something that Lung-Sun touched on earlier, so if we could come back to you once again to talk about how to ensure your witnesses isn't compromised, and then perhaps Jack can add a few final comments there as well.
Sure, thanks, Michelle. Well, there are quite a number of protocols which have been released, and I think the Seoul protocol on video conferencing was prescient because it was released before COVID-19. We have tribunals have taken ideas from all these different protocols, and one thing that I would normally do in procedural orders would be to talk to parties and counsel on what's the agreed procedure for witnesses. And one thing that we generally agree on is that there should be nobody in the room with the witness other than an IT person, so that you don't have this fear of interference. And sometimes we ask for the camera where the witness is, just to scan the room to make sure that there's nobody there. But we don't always resort to that because counsel tend to leave it to the integrity of each other, not to go to that length to hide somebody in the room. So you just need to understand in advance during the case management where the witnesses are going to be seated. Are they going to be at home? Are they going to be in a lawyer's office or in a third party's office? Related to that is, of course, how would the witness look at documents? I mentioned that. And it's good if you agree in advance that the witness will be given a set of documents that are clean, right? So that there are no notes in there for the witness to look at. And generally, counsel tend to agree on that, and they trust each other. But if you don't, you can always ask someone to be there and just look at those documents.
Thanks. Jack, anything to add there? Otherwise, there's another question for you. Maybe this is sort of adding on to the integrity of witness questions, but what do you do when parties don't want to agree on anything or collaborate? How do you proceed in that case?
Just to the former question, the only other thing I would add is that sometimes you may be able to actually have someone in the room from both sides with them, because you'd often at the hearing have someone helping the witness find documents and everything to keep things efficient. So depending on their location, maybe you have a junior associate from both teams in the room, something along those lines, not questioning them, but just helping with the documents. As far as what you do when people don't agree, I mean, that's why we have the tribunals in the end, right? Because in the end, the tribunal's got to have the discretion to simply make the decision and make the parties behave essentially sometimes.
Yeah, that's when we're going to call on the tribunal to help break up any. All right, I think we've got about 1 minute left, and Suksan, I just wanted to pose a final question to you. It is rather specific, but I want to make sure that our attendee gets his or her question answered. And then that question is basically, is there some sort of nationality requirement with respect to foreign lawyers being able to plead A, before the courts, and B, in arbitration proceedings? And specifically, is an Indian qualified lawyer able to do that? And do they need to speak Japanese?
I must say I'm not called to the Japanese bar, so I'm not 100% sure. But from my understanding, essentially, if it's an arbitration case, that shouldn't be any problem if it's a foreign lawyer who is providing legal services as a professional practitioner In terms of court, I think that would be a bit difficult. You would really need to be called to the Japanese bar in order to do so. I think that just now I mentioned something about registered foreign lawyer and non-registered foreign lawyers. So even if you're a non-registered foreign lawyer, you can still practice in an arbitration setting in Japan. That's my understanding, but of course I'm not a Japanese lawyer. Yeah, so I'll have to check that point out.
Thanks. And Jack, is that consistent with your understanding as well?
Yeah, I would just add, I actually am a gaiben, so registered foreign lawyer in Japan. What that means is that I'm able to directly advise Japanese clients on the law that I am qualified in. Lawyers who are not gaiben need to be supervised by a gaiben. So usually, if you're in a law firm, it's the partner or the counsel that you're working with who might be the gaiben, and if you're a junior associate, you're working with them and helping them provide the advice to the client.
And you don't need to know the Japanese language in order to be a gaiben.
No, you don't, as I can attest to, because I would say it in Japanese because I can't say it in Japanese, but my Japanese is still a work in progress.
All right, thank you very much for that insight. So to anybody out there listening that wants to work in Japan, you've got some great resources here. So that pretty much wraps up the time we have for the panel discussion. Thanks everyone so much for being a part of this. And it was really a pleasure to co-moderate this with Sue and to be a part of this panel.
It was a pleasure as well. Thank you. Thank you, Michelle. Thank you to all the speakers and to SIAC and KCAB International. Thank you.
Thank you.
Thank you. Thank you very much.
Thank you, everyone.
Okay, so we log out now.
Thank you, panelists and moderators, for the insightful panel discussion. That concludes this SIAC-KCAB International Seoul webinar. We hope that you've enjoyed the discussion. Why SIAC will be holding a virtual debate on Wednesday at 5 p.m. Korea time, and we hope that you can join us for that as well. More information is available on the SAF and SIAC websites. Have a great evening.